Straight ahead on Law&Crime Daily.
I don't want to be the Sandy Hook man. Okay, it was a very small part of whatever covered and did. And I followed a lot of the stuff being reported by 4chan that turned out to be wrong. I believe the children died. I've said that over and over again.
Defendant Alex Jones shows up for court, then leaves minutes later as the Sandy Hook defamation trial moves into its second week. Plus, what could be next for Adnan Syed, now that a judge has vacated his conviction after more than 20 years in prison for the alleged murder of his girlfriend. And several updates in the tangled web of Cleotha Abston, a man accused of killing Memphis teacher Eliza Fletcher and charged in a second attack. Now the defendant's mother is speaking out for the first time. Then later, the Pike County massacre trial of George Wagner IV.
You were considering either something that muffled the gun or possibly that they had been drugged such that they were not responding.
Would not wake up, that's correct.
Jurors hear from the forensic pathologist who performed victims' autopsies. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmeyer. The Alex Jones defamation trial stretches now into its second week in Connecticut, with testimony from a social media analyst giving insight to the effects of false content online over time. The case filed against Jones comes after he claimed that the 2012 Sandy Hook school shooting was a hoax put on by crisis actors to push gun control. The plaintiffs in the Connecticut case are made up of family members of 8 of the students and staff killed, plus an FBI agent, a total of 15 plaintiffs overall. They say Jones's followers have harassed them and even made death threats in the wake of his comments. Jones has already been found liable for the damages in this case, meaning jurors will decide how much Jones should pay out. He was already ordered to pay $49.3 million in a separate defamation case out of Texas. Media outlets caught up with Jones as he arrived to the courthouse Tuesday, and again as he subsequently left moments later, when he learned he would not be testifying just yet.
I'm here to testify. I'm here to do what needs to be done. This is now, will be the second time they've changed when they said they'll let us know later when or if they want us here.
So you're not testifying today?
No, I'm not testifying today. I'm obviously going to have to sit here until the trial's over because they keep jerking me around, and that's fine. It's just that I'm here to testify, and I'm here to tell the truth. And I told the truth. I apologized on Joe Rogan 4 years ago, episode 1255, for 30 minutes before I was ever sued. I don't want to be the Sandy Hook man. Okay, it was a very small part of whatever covered and did. And I followed a lot of the stuff being reported by 4chan that turned out to be wrong. I believe the children died. I've said that over and over again. I've been apologizing for 6 years, 4 years ago on Joe Rogan, 3 years ago on Steven Crowder. There's hundreds of apologies. But now when I go on shows, they say, do you want to apologize? I go, no. I've apologized over 100 times. I'm not the guy that started questioning Sandy Hook. I did for a while believe it might have been staged. I thought Jussie Smollett was staged. Turned out I was right. I thought WMDs in Iraq were staged. Turned out I was right. But I did not premeditatedly create this whole story to, quote, make money. It's hurt me over the last 10 years.
Once testimony did get underway, social media analyst Clint Watts took the stand to talk about how he was asked to consider what effects of false information there could be on Jones's audience and how it might change their perception of reality.
And when you are using these emotions, fear, anger, demonization against a target, do you have experience in, does that expose the target to increased risk of harm?
It does. If they have used information to change people's beliefs or perceptions, it will lead them at times to pursue harms against a target.
And have you observed and examined how these types of narratives lead to harassment in an online community?
Absolutely. The range is everything from harms against children. It can be involved in terms of criminal activity, mobilizing people to target an individual under false pretenses. I think the one consistently through my career is extremist, meaning that terrorist groups use this sort of information manipulation to make people angry to pursue things as a target.
Joining us today is criminal defense attorney Bernardo Villalona and co-host Terry Austin. Bernardo, Jones was in full form outside the courthouse. Could what he does outside the court add more dollars to how much he must pay in the court?
Absolutely. Whatever Alex Jones says out in the street in the public can be used against him when he testifies before this jury. He can be confronted with all his statements. And all his statements all seem as he's coming off very harsh, very strong, very in terms of that he is fulfilling this lie and still believes this lie, despite him saying, oh, I apologize, but you're doing that because you know there's a trial going on. He is feeding into his base. This is who he is.
All right, now Terry, what was your impression of Watts on the stand or standing kind of in the courtroom? Do you think the jury understood his message overall?
Well, you know, it was a complicated message, but I think he was excellent delivering that message. He basically is extremely highly educated. He went to West Point. He was trained at Quantico. He was in the military. He was an FBI agent. And he clarified what his analytic process was. He talked about the 4 M's, the message, the messenger, the medium, and the method. And I thought he did an excellent job talking about how Alex Jones and InfoWars made sure they did all of that. They based everything in fear. They created the audience. They used different mediums like social media. They had an infrastructure. So I think that he was very good. I will say, however, that I think the defense attorney was having difficulty formulating his questions, and he kept having to rephrase. And that can be a little bit annoying to the jury. And perhaps the witness didn't come across as well because of that.
All right, we'll see how the jury contemplates defamation charges and fines after this more testimony in this case. And Broadway star and TV actress Laura Osnes has filed a lawsuit against the New York Post for defamation over an article published a year ago. Osnes is claiming the newspaper lied, causing harm to her reputation, both professionally and personally, and that their actions caused emotional distress. The article at the center of the suit claimed Osnes was fired from a special performance of a planned revival of the musical Crazy for You for refusing to get a COVID-19 vaccination. Days after the article was published, Osnes posted a statement to social media saying she had withdrawn from the production, not that she had been fired. Osnes took to social media to express her opinions over vaccine mandates and says she would back out of the production because she hadn't been vaccinated. The actress was also replaced in a London production of Bonnie and Clyde. Osnes is seeking at least $5 million in damages. Still ahead on Law and Crime Daily, Cleotha Apston's mother speaks out after her son faces several charges in the attack of one woman and in the murder of Memphis teacher Eliza Fletcher. But first, the next steps for the newly released defendant Adnan Syed after the vacating of the 2000 murder conviction. Welcome back. Maryland officials now have 30 days to decide whether they will fully drop charges against Adnan Syed, the man whose 2000 conviction for the alleged murder of his girlfriend was overturned late Monday afternoon. Once Syed left the courthouse, he was met with cheers. Then officials held a press conference after the decision was announced.
My office petitioned the court jointly with Erica Suter from the Office of the Public Defender and asked that Adnan Syed be given a new trial where he is adequately represented and the latest evidence presented in the interests of fairness and justice, which is and has always been the hallmark of my administration as State's Attorney for Baltimore City. At this stage, a trial has been set in for a new trial date because we're not yet declaring Adnan Syed is innocent. But we are declaring that in the interest of fairness and justice, he is entitled to a new trial.
Adnan Syed's case rose to fame in 2014 when the podcast Serial broke listening records. The investigative series cast doubt on his 2000 conviction for the murder of his high school girlfriend, 18-year-old Heyman Lee. He has been behind bars since his 1999 arrest, and since then, Syed has maintained his innocence. Terry, unreliable cell phone tracking, alternative suspects, and a shoddy investigation. What piece of evidence gives you, if any, doubt that Syed got a fair trial?
You know what, Brian, based on all of that evidence, in my mind, there's no doubt that Syed did not get a fair trial. And as you well know, as a defense attorney under the Sixth Amendment, every defendant is entitled to, one, a speedy trial, competent counsel, an impartial jury. He has to know what his accusations are against him. He has to know the nature of the charges. But the most important thing here in this case, the evidence against you. And there was exculpatory evidence against him that he did not get an opportunity to pursue. And that included, as you said, the existence of alternative suspects that could have made a huge difference in this case. It won't bring back the decades he spent in jail, but it would vindicate him if he gets an opportunity to have another trial, or if the prosecution decides not to bring another trial at all.
Yeah, not just that he didn't get it, but also the jury didn't hear it either in deciding guilt or not guilty. Bernardo, the clock is ticking as the prosecution has 30 days to decide if they will retry Syed. So what are the next steps for both the prosecution and defense?
So the next steps for the prosecution, and that be State's Attorney Marilyn Mosby, who's heading up this office, is for them to determine, number one, does Marilyn Mosby believe in the guilt of Mr. Syed? And number two, do you have enough evidence, credible evidence, to prove this case beyond a reasonable doubt? Because we know from the trial there are huge issues in terms of credibility. So I'm not sure that they will have enough in order to retry Mr. Syed if, in fact, they believe that he is guilty and that a jury should listen to this case. But the biggest injustice is just how Terry said, look, you had exculpatory evidence and that was not turned over. Being a prosecutor is about pursuing justice, not merely conviction. And this was a huge travesty for the criminal justice system, for those prior prosecutors to have held on to exculpatory evidence.
Absolutely. I'll leave it at that because, Bernardo, you said it perfectly. Switching to Ohio, where a physical confrontation during a traffic stop turns violent between a man and a female cop. Then, several Good Samaritans stop to help, and it all is caught on camera. Take a look.
Day 12 radio traffic stop.
Hello. Officer, I will be placed on it. The reason why I'm stopping you is speed. 57 and a 35. Why are you getting out of the car, sir?
I gotta get my driver's license.
12 radio, this male just stepped out of the vehicle. Step over here now. Have a seat on the ground. Have a seat.
I'm not sitting. I'm not sitting!
Back up! Back up!
I'm not sitting, mother.
Put your hands behind your back.
I'm not sitting.
I will tase you, sir.
What the? Son of a knock it off, man.
Get your cuffs, get your cuffs.
Shut up. Shut up.
You don't do that to a woman. Do you understand me?
64-year-old David Kubek is facing several charges, including assaulting a police officer, speeding, and driving without a seatbelt. Coming up on Law and Crime Daily, a Memphis man's second accuser is speaking out against police after it took a year and a murder to charge Cleotha Apston with the assault. Plus, the forensic pathologist who performed the autopsies in the Pike County massacre case takes a stand in the trial of George Wagner IV. Welcome back. District attorneys in Las Vegas, Nevada are seeking to remove Clark County Public Administrator Robert Tellis from office after the politician's arrest on murder charges. Tellis allegedly killed prize-winning investigative reporter Jeff German on the Las Vegas Review-Journal earlier this month. German, known for his hard-hitting investigations of government corruption and the mob, had recently published a series of investigative reports on Tellis, accusing the official of abusing the resources of his office, bullying staff, and having an inappropriate relationship with a female staffer, even though he's married. Tellis lost his bid for re-election following the newspaper expose. Investigators say Tellis was seen on surveillance video at German's home. The next day, he was found stabbed to death. The defendant appeared in court Tuesday morning for a brief hearing. His attorney was excused and replaced, and he was ordered to be held without bail. Tellis is scheduled to return to court for a preliminary hearing October 26th. And in Tennessee, the alleged first victim and the now defendant's mother are speaking out in the case of Cleotha Apston, as the 38-year-old faces a slew of charges, including rape and murder. Apston was arrested earlier this month after Memphis teacher Eliza Fletcher went missing while out on an early morning jog. Weeks later, Apston was charged in a second attack, which happened in September of 2021. Alicia Franklin broke her silence this week, identifying herself as the victim in that case. She says Abstin blindfolded her, held a gun to her neck, took her into an abandoned apartment, and raped her. Though she says at the time Memphis police dropped the ball on her case, not processing her rape kit for 11 months. Now, Abstin's mother is also speaking out for the first time since her son was arrested for murder, insisting Abstin is innocent. Virgie Abstin claims her son is being, quote, railroaded for a violent crime. Abstin was due to appear in court Monday, but the hearing was rescheduled for September 28th. Terry, Alicia Franklin is speaking out against the police, basically saying if they didn't dismiss her, a future attack may not have happened. Do you sense any civil rights claims against the Memphis police by either victim's family?
Well, it is possible that both victims could potentially pursue some civil rights claims. Alicia Franklin, as you mentioned, she had that rape kit that wasn't properly analyzed, and Eliza Fletcher, her death, it might have been prevented. And you can bring a civil rights action under Section 1983 of the Civil Rights Act if the wrongdoer was acting under color of law or legal authority. So they could potentially bring a claim for failure to, have equal protection or due process under the 14th Amendment. I think it will be difficult, though, because I think there might be a qualified immunity here that they could certainly argue in defense of that claim.
Agreed. Bernardo, there seems to be a lot of lessons to be learned here by many attached to these two cases. Assuming Cleotha is found guilty, what else needs to change to ensure multiple abductions by the same man doesn't happen again?
Well, I think what needs to be changed is that there has to be some kind of database that's kind of worldwide or actually around the country. So that way different police stations can be able to look at common threads that are going on in different counties so they can be on the lookout and also give notice to other counties in terms of, look, I have something that was similar that happened here. So you need to take this into account because possibly this can be taking place in your county.
Yeah, I like the idea. We've got to somehow work better together to protect each other. Well, when we come back, jurors hear testimony from the forensic pathologist who conducted all 8 autopsies in the Pike County massacre, as George Wagner IV stands trial for his part in the murders of the Roden and Gilley families. Welcome back to Law&Crime Daily. Jurors in Ohio hear detailed testimony about the injuries the Roden and Gilley families suffered in the Pike County massacre case as George Wagner IV stands trial for his role in the murders. 8 members of the Roden and Gilley families were shot to death in their homes in April of 2016. Most of them were in their beds. Investigators initially thought the killings could be drug-related, but later determined the murders came amid a custody dispute involving a young child George's brother shared with Hannah Roden. George, his brother Jacob, and their parents were later charged with murder. Jake and their mother Angela pled guilty to the charges. They are expected to testify against George. Testimony Tuesday began with forensic pathologist Dr. Karen Lohman with the Hamilton County Coroner's Office, who testified about the victims' injuries. She told the jury about what stood out to her as she began performing the autopsies.
It became apparent looking at where the wounds were that it seemed that many of them were shot multiple times and never moved, never appeared to have reacted to other people in the house being shot as well. And so in my mind, I was trying to figure out why somebody wouldn't respond when other people in the house are getting shot. I think they would wake up with gunfire. So one of the things I did was did a little bit of extra toxicology to see if maybe they'd been drugged and they were all didn't wake up because they were sleeping. And another thought was, well, mostly it was the drugs I was concerned about, that maybe they had drugs. The other thought, though, was that maybe there was something that was muffling the gunfire, but I can't find evidence on the body that would suggest that there's something that was muffling the fire. That's not something I could see.
Bernardo, how do you think Dr. Lohman testified? Was it dry science of a victim's final moments, or did it paint the picture of the brutality of their deaths?
Well, to hear testimony from the coroner, medical examiner, depending on the state, they have different names. It's very intriguing and intriguing. Why? Because it shows you the heinous of the actions of the shooter, of the killer, of how many times that each of these victims were actually killed and that there were no defensive wounds, that they didn't even expect it. So the testimony of a coroner or a medical examiner can give you a lot of information that despite that person not being alive, being able to testify, the body speaks volumes.
Yeah. Now, Terry, the coroner's testimony seemed pretty straightforward. Do you think the defense can or did poke any holes in her testimony on cross-examination?
Well, I think if I had been the defense, I would not question that coroner at all. There were not many discrepancies in her testimony, if any. For instance, she talked about a computerized chain of custody, so there's no question about contamination. She's well educated, so there's no question about her qualifications. But I suppose one of the areas the defense could pursue would be the fact that this coroner herself was the one who examined all 8 individuals. She did all 8 autopsies. And I suppose you could question, would not it be more efficient if you spread out the work, you could get to the body sooner? But there's no evidence that there was any delay that would have caused a different result. So I don't think there's any holes here.
Absolutely. Probably don't cross-examine her like you said. Well, thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.